A very, very good evening to all of you friends. A very warm and a hearty welcome to each and every one of you. So friends, welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exam. In this session today, I shall be discussing about certain very, very important current legal affairs. Some important development that each and every one of you preparing for this particular CLAT examination as well as your ALET examination must be clear about. I'm going to discuss with you certain very recent Supreme Court and High Court judgments. So here we come with this particular session where we try to discuss with you certain very important legal current development. Because as a student who is preparing for these examinations, understanding the recent development of law becomes absolutely crucial. So bear with me this particular session wherein I shall be discussing with you certain very, very important legal development. So a very, very good evening to each and every one of you. Welcome to this session on legal current affairs. Not only I'm going to discuss with you certain important current affairs, but there will be certain important multiple choice question for you guys to answer, because understanding the law is different, but when it comes to solving question, are you able to solve these questions? That is what precisely I shall be looking at. So guys, let's begin. Now, what is the agenda for the session? Number one, there is a Calcutta High Court judgment that has come out very recently, which deals with the concept of defamation. What has the Calcutta High Court said about intention or the concept of mens rea when it comes to law of crime, law of defamation? So in case a person had the intention to harm someone's reputation, yes, it is defamation. But in case the person did not had that mens rea, will it amount to defamation? Let's see what the Calcutta High Court had to say about this. Another very important judgment from the Supreme Court. Larger bench will prevail over smaller bench judgment. As you know, a 5-judge bench, a 7-judge bench, a 9-judge bench, 11-judge bench, right? So there are various larger benches of the Supreme Court which renders decision. Now, there was this conflict insofar as a 7-judge bench is concerned. Suppose a 7-judge bench gives a judgment. And now, there are 4 judges who has said yes, and suppose 3 judges has said no in a 7-judge bench. Now, suppose a 5-judge bench judgment is there where all the 5 judges are saying yes. Now, should 4 judges in the 7-judge bench which said yes, should it stay? Or will a 5-judge bench which is giving a unanimous judgment, all are saying yes? Now there was a conflict because a 7-judge bench where the majority judgment is just by 4 judges and 3 judges has dissented. What is the law? Let's see that also. Thirdly, I shall also be discussing with you a judgment on criminal law wherein the Supreme Court said that the gravity of the crime, the intensity of the crime, the magnitude of the crime is of a great importance when it comes to deciding the punishment that is to be awarded. So when punishment is to be awarded to a person for having committed a particular offense, the gravity of the crime, the intensity of the crime has to be of prime consideration. These are the three things that I am going to discuss with you. But before we start, before I begin, BYJU'S Exam Prep brings to you the test series. All of you, I know most of you have already got this test series. Those who haven't, please get it today itself. You do not have much time. You have less than a month's time. So with around 20 odd days for your preparation, I'm sure mock test is going to help you up in a big way. BYJU'S Exam Prep is providing you 45 mocks, okay? 45 mocks, which covers all law entrances, 20 CLAT, 25 non-CLAT, 9,000 practice question, test covering every single subtopic. There will be 3 All India Mega Mock with video solutions, a detailed mock analysis based on the actual exam pattern, which are created by NLU alumni themselves. So those of you who haven't, get it today itself. So guys, let's begin with the first important judgment coming from the Calcutta High Court. Now, there was this particular case wherein the editor of a newspaper had written certain things against a particular individual. Now, that individual went to the court and said that that article, that news reporting has caused defamation, has caused harm to his reputation. Now, the Calcutta High Court very categorically said that if the maker of the statement, editor, writer, author, had no intention to cause harm, very important, had no intention to cause harm. Now, under the criminal law, mens rea and actus rea constitutes a crime. Am I clear? Both mens rea and actus rea, both must be present in a crime. Now, if the intention or the mens rea element is not present, if the mens rea element is not present, will that amount to a crime? Let's see what the judge has to say. It is right to say, it is absolutely correct to say that to constitute an offense within the meaning of section 499, that is defamation, there has to be imputation which is the basic requirement, and such imputation shall have to be made in the manner as provided in the provision with the intention, very important, with the intention of causing harm or having reasons to believe that such imputation will harm the reputation of the person against whom it is made. Causing harm to the imputation of a person is the basis on which this offense of defamation is founded. And like every criminal proceeding, mens rea is a condition precedent to constitute such an offense. So mens rea or your intention is an absolute condition precedent. It's one of the most important element of a crime. Now, if mens rea is not present in a particular act, can it be called a crime under the law? The Calcutta High Court says no, it cannot be called. It cannot be called. That is the reason given by the Calcutta High Court. Am I clear? Am I clear to each and every one of you? Am I absolutely clear? Okay. Furthermore, the Calcutta High Court says that a criminal offense, it goes without saying, emphasis on the intention of harm. This section 44 of the IPC defines injury and it denotes harm whatever illegally caused any person in body, mind, reputation or property. In the absence of any ingredient prima facie to show that mens rea of the accused person to have the intention, knowledge or reason to believe that the report published in the daily newspaper, that was the Ananda Bazar Potrika, an offense within the meaning of 499 cannot be said to have been made out. So unless there is intention, an act without mens rea or intention is not an offense. Is that clear to each and everyone? An act without your intention, without mens rea, cannot be called as an offense under the Indian Penal Code. Am I clear? Okay, let's move on. Next, a very important judgment. Now, let me give you a scenario. Suppose there is a 7-judge bench wherein the majority is 4:3 and there is a 5-judge bench where there is 5:0. All the judges over here, a 5-judge bench, 5 judges agree. There is no judge which disagrees. And there is a 7-judge bench judgment where 4 judges agree, 3 judges don't. Will the 7-judge bench overrule a 5-judge bench? Or will that 5-judge bench, because it is unanimously given, because 5 judges, if you see how many judges, 4 is less than 5. Are you understanding this concept? Which judgment will have a precedential value? Which judgment? Tell me. Will the 7-judge bench have a precedential value or the 5-judge bench which has given a unanimous judgment? Tell me. Alifia Yusuf Ali says 7-judge. Okay, a larger bench. Yes, that's the answer. The Supreme Court says that judgment by a larger bench will prevail irrespective of the number of judges giving the majority. Judgment of 7-judge bench, which 4:3 majority, will prevail over a unanimous judgment by 5 judges. Very, very important. Very, very important. Very, very important. The Supreme Court says, I don't know how many judges said what. What is the maximum strength of the bench? The larger bench will prevail over one delivered by a smaller bench. Am I clear to each and every one of you? Is that clear? Okay. Did you all understand this concept? Did each and every one of you understand? Okay. What did the judge said? Justice Indira Banerjee of the court said, if a unanimous 5-judge bench decision is overruled by a 7-judge bench with 4 learned judges speaking for the majority and 3 learned judges speaking for the minority, can it be said that the 5-judge bench has been overruled? Under the present practice of the court, it is clear that the view of 4 learned judges speaking for the majority in a 7-judge bench will prevail over a unanimous 5-judge bench decision because they happen to speak for 7-judge bench. Has the time come to tear the judicial veil and hold that in the reality, a view of 5 learned judges cannot be overruled by a view of 4 learned judges speaking for the bench of 7 judges? This is a question which needs to be addressed and answered. Now, she says that yes, as of now, the law is this. This is the custom of the courts, that a larger bench of 7 judges, where you have 4:3 majority, where 4 judges are speaking for the 7 judges, will have precedential value and can overrule a judgment given by a 5-judge bench where it was all the 5 judges has unanimously spoken. Is that clear? Did you all understand the basic concept of this particular case? Sorry. Is that clear to each and every one of you? Is that clear? So guys, if you're liking this session, do press the like button and share this session with your friends. Do press the like button and share this session with your friends. Okay? Okay. Justice Banerjee also said about precedent. A judgment delivered by a larger bench will prevail irrespective of the number of judges constituting the majority in view of Article 45, subclause 5 of the Constitution. Concurrence of a majority of the judges at the hearing will be considered as a judgment or opinion of this court. It is settled that the majority decision of a bench of larger strength would prevail over the decision of a bench of lesser strength, irrespective of the number of judges constituting the majority. That is what Justice Banerjee in the judgment had to say in the Supreme Court. Is that clear? Is that clear? Everyone? Every one of you. Everyone. Okay? Okay, let's move. Another very important judgment from the Supreme Court. Gravity of the crime is of great consideration when it comes to deciding the punishment. The Supreme Court said that the gravity of the offense, when it is of a great importance when a judge is determining the punishment, because the minimum sentence, now for every offense there is a minimum sentence and a maximum sentence. X offense, 2 years, maximum 5 years, 7 years, maximum 12 years. So there are various offenses where you have the minimum sentence and the maximum sentence. Now, in such situation, when should a person be given minimum sentence and when should a person be given maximum sentence? How to determine that? How to answer that? How should judges determine how much of sentence should be awarded? Now, in criminal law, the Supreme Court said that the gravity of the offense, the gravity of the crime should be of great importance insofar as deciding punishment is concerned. A criminal trial sentencing, gravity of crime is of prime consideration. Maximum sentence for an offense under 326 is imprisonment for life. That is the maximum. But how do you choose whether a person should be given maximum sentence or not? And the thing is, and the simple rule the Supreme Court says is understand the gravity of the crime. Justice Oak of the Supreme Court says gravity of the crime is of prime consideration for deciding what should be the appropriate punishment. It is always the duty of the court, very, very important. It is always the duty of the court to balance aggravating circumstances and mitigating circumstances at the time of imposing sentence. If undue sympathy is shown by reducing the sentence to the minimum, it may adversely affect the faith of people in efficiency of law. The judicial discretion is always guided by various considerations, such as seriousness of the crime, circumstances in which crime was committed, and the antecedents of the accused, that means previous acts of the accused. That these are certain serious things that a judge must keep in its mind while awarding a punishment. Am I clear? Is that clear to each and every one of you? Is that clear? Is that clear, everyone? Any doubts? Any doubt? Tell me. Okay. Brilliant. Fantastic. 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 Great to see. Great to see that. Great to see. Okay. Fantastic. Fantastic. So, this is all very important legal developments, and I want each and every one of you to have a good understanding of it. Because unless and until you understand these things, it will not be of great use. Okay. How to crack ALIT? Okay, here's the question. Ronak Thakur says how to crack ALIT. Practice. Now, insofar as your legal reasoning is concerned, the kind of question you will get is all principle and fact-based questions. So you need to have a good understanding of how to solve principle and fact-based questions. Secondly, they might also ask some legal knowledge questions. Okay, legal knowledge question whereby you will be given certain questions. They are going to test your legal knowledge. Right? Who is the Chief Justice of India? Who is the Attorney General of India? Who is the first Law Minister of India? The present Law Minister of India? Or what does the Vishaka guidelines deal with? I'm sure you guys are aware of. What is the principle of double jeopardy? And there will be 4 options given to you. So you need to have understanding of the law, definitely. And secondly, you also need to have a good knowledge of the law. Okay. Prepare for vocab. I think I am not the right person to give you that answer. You should ask to the English faculty. Okay. Maxims are important. Maxims are important. Venkatesh. Maxims absolutely do play a very important role. They might ask you, what is the meaning of mens rea? What is the meaning of actus rea? Okay. Yeah. ठीक है? Okay. Chalo. Now, before moving on to the questions, BYJU'S Exam Prep brings to you the last lap to CLAT 2023 25 power pack session, must do topics, practice question based on exam pattern, paper solving skills and tips. Starts from 5th of November at 9 p.m. Let's start with the questions. Are you all prepared to start with today's a couple of questions? Okay, let's see. The first question is up there on your screen. Read the question and give me the right answer on the chat box. The Supreme Court recently allowed women regardless of their marital status, to be entitled to safe and legal abortion within 24 weeks of their pregnancy, starting that differentiation between married and unmarried women under abortion law was artificial, constitutionally unsustainable, vulgar, both artificial and constitutionally unsustainable. The Supreme Court has said that irrespective whether a woman is married or not, if she is pregnant, she is entitled to 24 weeks of pregnancy leave. Okay. Then she can go for an abortion within 24 weeks under the abortion laws. Yeah, let's see the answers. Okay, option D. Okay, it is both artificial and constitutionally unsustainable. So the correct answer is option D. Absolutely correct. The Supreme Court has said that this differentiation between a married woman and a non-married woman is absolutely artificial and constitutionally unsustainable in the eyes of law. Very good, brilliant. Let's move to the next question. The Supreme Court recently allowed safe and legal abortion until 24 weeks to women regardless of their marital status, stating that the right of reproductive autonomy, dignity and privacy is provided under which article of the Indian Constitution or which section of the Indian Penal Code? Okay, the correct answer is Article 21 of the Indian Constitution. Article 21 of the Indian Constitution provides Article 21 of the Indian Constitution provides right to life and personal liberty. Absolutely correct, each and every one of you. Okay, is provided under Article 21 of the Indian Constitution. Article 21 of the Indian Constitution. Okay. 21A deals with right to education. That's different. Somebody has said Article 21A. No. Article 21A deals with right to education. Am I clear? Question number 3. Who is the following is the new Attorney General of India? K.K. Venugopal, R. Venkatramani, Mukul Rohtagi, Gulam Ehsanji Vanvati. The correct answer, all of you know, is Mr. R. Venkatramani. Mr. R. Venkatramani has been appointed by the President as the new Attorney General of India after Mr. K.K. Venugopal gave that position away because of his old age. Okay. Mr. R. Venkatramani, a senior advocate of the Supreme Court, has been appointed as the Attorney General of India for the next 3 years. Now, the Attorney General of India is appointed by the President under Article 76 of the Indian Constitution. He is the senior most law officer of the country. That's very, very important. Question number 4. Who amongst the following appoints the Attorney General of India? Okay, Prime Minister, Chief Justice, President of India, Supreme Court Judge. I think all of you will give me the right answer because in the previous answer itself, it was categorically stated that the President of India appoints the Attorney General of India. Very well, very good. Keep it up. You guys are doing absolutely brilliantly. Okay. So the Attorney General of India is appointed by the President. Who is the President of India? Srimati Draupadi Murmu. Srimati Draupadi Murmu is the President of India. Okay. Very, very important. Question number 5. Union Home and Corporation Minister Amit Shah has recently announced the formation of a committee to draft which of the following? Is it the National Cooperation Policy Document, Anti-National Activities Restriction Document, Pandemic Activities Restriction Document, or Environmental Protection Policy Document? The Union Home and Cooperation Minister, Shri Amit Shah, has announced the formation of which of the following committee? Let's see. The correct answer. It is the National Cooperation Policy Document. Okay. The National Cooperation Policy Document. A 47-member committee will be headed by former Union Minister Sri Suresh Prabhu to draft this National Cooperation Policy Document. Is that clear? Very, very important. Very, very important, guys. Please, I am sure that you guys are noting all these things down. Right? Okay. Before moving ahead with further questions, these are some of the classes that you cannot miss. 9 p.m. on the 21st, you have Ankur sir taking a class. 23rd, Alpha ma'am. 25th, Ankur sir again. 27th, Nivedita ma'am. 28th, Abhimanyu sir. Okay, I'm sure that you have taken a photo click of it. Okay, let's come to question number 6. Lok Sabha have not to New Delhi International Arbitration Center Amendment Bill of 2002. This bill seeks to rename New Delhi Arbitration Center as which of the following? By virtue of this amendment, the New Delhi International Arbitration Center will be known as what? Will be known as India International Arbitration Center. Will be known as India International Arbitration Center. Absolutely correct. Very good. Okay. Okay. So guys, if you are enjoying the session, do press the like button. If you are enjoying this session, what prevents you from pressing the like button and sharing this video with your friends who all are also preparing for CLAT and other law entrance examination? Okay, is that clear? Fantastic. Let's move ahead. August 2022, the Lok Sabha has given a nod to the New Delhi International Arbitration Center Bill of 2002. The bill seeks to rename the New Delhi Arbitration Center as India International Arbitration Center. India International Arbitration Center. Okay. Moving on. Question number 7. Who was the first Attorney General of India? B.N. Agarwal, M.C. Setalwad, R.K. Agarwal, Hiralal, Jaisuklal Das, Kania. Who was the first Attorney General of India? Please give me your answers fast. Somebody says C. Okay, Vinayak says C. Rakhi Agarwal says D. I'm sure that you must have heard about the first Chief Justice of India. He was Hiralal Kania. Justice Hiralal Kania was the first Chief Justice of India. Yes, the correct answer is Justice M.C. Setalwad. Justice M.C. Setalwad was the first Attorney General of India. So the correct answer happens to be option B. Option B. Okay. Now, there are also very, very important sessions coming up. 5th of December Krishnendu sir. 6th, Nivedita ma'am. 7th, Abhimanyu sir. 8th, Krishnendu sir again. 9th, Ankur sir. Then on 17th, you have again Krishnendu sir. Then on 20th, Shalik sir. 22nd, Krishnendu sir. 24th, myself on ALIT Legal Reasoning Most Expected Question Part 2. And on 27th, you will be having a session with Shalik sir. I'm sure that you guys are aware of this schedule. This is the ALIT 2023 crash course, which is on air, okay, which will be live on our YouTube platform. We are doing it free of cost for everyone. So guys, with this, we come to the end. Do subscribe and press the bell icon. Do follow us on our Instagram page. Do like our Facebook page. Do join our channel, our Telegram channel. And by the way, do not forget to miss the app. Just download the BYJU'S Exam Prep app. The link is given in the description box, because a lot of things are provided free of cost to students out there. So guys, with this, we come to the end of this session. Thank you very, very much. Namaste. Thank you. All the very best. Okay, bye-bye. Take care. All the best. All the best. Bye-bye. Take care. Okay, thank you. Thank you.